All right, welcome back to the House Government Operations and Military Affairs Committee. We have received an amendment, Senate proposal of amendment to H517. You'll recall this was the dissolution of the Moortown Waterbury Fire District number 1, Duxbury Moortown Fire District number 1 bill. This language very clearly in draft number 1.2 has absolutely nothing to do with the fire district. That the Senate, at the request of the Department of State's attorneys and sheriffs, has added some language on here. And what we're going to do is have legislative counsel just kind of walk us through what the language is. And then Evan from the Department of State's attorneys and sheriffs is going to talk to us a little bit about why the request. So I appreciate everybody meeting once again here. And I thought our taking action was done for the day, but we have a little more work to do. So Jen, thank you for walking us through this.
Sure. Good afternoon, Jen Kirby, Legislative Counsel. So we are looking at, as the chair said, a Senate proposal of amendment. I think the document itself may still be in process of becoming a Senate proposal, but it would add a new section 1A. It puts in and amends an existing section of statute 24 VSA section 363 on deputy state's attorneys. Under the existing law, a state's attorney can appoint as many deputy state's attorneys as necessary for the proper and efficient performance of the office and may remove them at pleasure. This would create another opportunity to appoint, allowing the executive committee of the Department of State's attorneys and sheriffs to authorize or direct the department's executive director to appoint deputy state's attorneys who shall have all of the same powers and duties of other deputy state's attorneys, except that they may prosecute cases in any county of the state. And it allows the executive committee to limit the term and scope of any such appointments and may remove these deputies at the committee's pleasure, which is the same standard as for the state's attorneys appointed ones. Then there's some conforming, the rest of it is basically conforming language, talking about under existing law, the pay for deputy state's attorneys is set by the executive director or through collective bargaining, but can't exceed the pay of the state's attorney making the appointment. And then this says, or other appointing authority if they're appointed under this alternative process. No changes in existing subsection C. And then in subsection D, there are, again, a couple of kind of conforming changes. So this would specify that if appointed and under oath, a deputy state's attorney, and it clarifies who is appointed by the state's attorney, may prosecute cases in another county if the state's attorney in that other county files the deputy's appointment in the other county clerk's office. It's not, so this specifies that that's just for deputy state's attorneys appointed by a state's attorney, because those appointed by the executive director would have statewide jurisdiction or statewide ability to appear. And in the case of a vacancy in the office of state's attorney, the appointment of the deputy under current law expires upon the appointment of a new state's attorney. This would say, except for a deputy appointed by the executive committee or executive director. So just some kind of clarifying and conforming changes about how that new appointment option would work with respect to deputies appointed by the state's attorney and deputies appointed by the executive committee.
Representative Hango.
Thank you. So currently the deputy state's attorney is appointed by the state's attorney in that count for work in that county only.
Yes, except that there's the ability to
if it's filed with another county.
Right. So you'll hear from Evan, for example, is a deputy who's authorized to appear in all 14 counties.
Okay.
So some do have authority, but they have to do it on a county by county basis and get the approval of have to get the approval of the receiving state's attorney. County that they're looking to get the authority to prosecute in. And just because this came up, there was some confusion, I think, in the other chamber about deputies. There are generally multiple deputies in any county, deputy state's attorneys in any county, so it's not a single position that's a deputy state's attorney. They're the folks who work under the state's attorney currently to prosecute cases.
Any other questions about the words on the page? Thank you very much, Jen. I'd like to invite Evan Meehan, who's from the Department of State's Attorneys and Sheriff, and is himself a Deputy State's Attorney. Welcome.
Thank you very much. For the record, my name is Evan Meenan, and I am a Deputy State's Attorney. I think to best explain the purpose of this amendment, I'll explain a little bit about how things work and then frame how the impact of these changes through the lens of my position and a couple other positions. So right now, the Executive Director's Office, which is located just across the street, has control over the budget for all 14 state's attorneys' offices, which means effectively it decides how many deputy state's attorney positions each office is going to have. It doles them out. Chittenden gets this many, Washington gets this many, so on and so forth. The actual state's attorneys in each of those counties are the ones that select who they would like to deputize. So let's say Washington is given 5 deputy state's attorney positions. They are the ones who normally say, these are the 5 individuals who I would like to be my deputies. And then the state's attorneys are the ones who administer the oath, swear them in, formalize the deputization, and then take that oath, that piece of paperwork, and file it with the county clerk. And then those deputies can act as prosecutors and start to handle cases. When the state's attorney leaves, for whatever reason, there's a vacancy. Maybe they retire, maybe they resign, maybe there's an unfortunate health-related issue, some vacancy. The deputy state's attorneys in that county can continue to prosecute their cases until a new deputy state's attorney arrives. So let's say the Washington County State's Attorney decides to retire and there's still time left in their term. The cases are not interrupted. They can still be prosecuted. The governor appoints a new state's attorney. And then once that state's attorney is appointed, they have to decide, am I going to re-deputize my 5 prosecutors or pick new ones? And that's up to them. The deputies in any particular county, as a general rule, can only prosecute cases in that county. So if you're a Washington County Deputy State's Attorney, you prosecute counties in Washington County only. There's a couple of ways around that. The first thing that could happen is a Washington County Deputy State's Attorney could say, hey, Lamoille County, would you like to also deputize me? And then I can prosecute cases in your county. And that state's attorney may say yes, or they may say no. And that would require them to go through the same process of taking the same exact oath, filing it in that county. So it is possible to prosecute cases in more than one county. I am a living example of that. And so are a couple other attorneys assigned to the executive director's office. So I am technically a deputy state's attorney in all 14 counties in Vermont. And so are, for example, our 2 statewide traffic resource prosecutors who handle things like serious motor vehicle fatalities and things of that nature. In order to become a deputy state's attorney in all 14 counties, I had to go around the state, take the same exact oath of office in front of 14 separate individuals and file the paperwork, right? And I have to do that every single time there's a change in any one of those offices. And the same is true for the 4 other attorneys assigned to the executive director's office. That seems like an easy thing to do. I can tell you that it took up not hours, but days of my time to accomplish that process. So one thing that this bill would do is simplify that administrative burden and make it possible for folks like myself who prosecute cases in every single county to take one oath, one time, and simply file it in 14 places. It's much easier.
In that regard, you're telling me that that oath you take in all the other 13 counties isn't good for any more than, what, a month? Shouldn't it be for a period of time?
It's good until there's a new state's attorney, either by election or a vacancy and then an appointment. So for example, in Addison County, the state's attorney was Dennis Wigmans. He is now one of our statewide traffic resource prosecutors. And Ava Vakos is our new Addison County State's Attorney. Well, Dennis had appointed me as a deputy. I had to ask Ava, would you continue to like my assistance in your county? If so, can you please administer the same exact oath and I'll file it in the same exact office? And we did that and it was fine. It worked. We had a lot of changeover in the department this year, lots of new state's attorneys, and we had to go through the paperwork process. Again, it's not the end of the world, but this would streamline that administrative burden.
Representative Hango.
Thank you. So the very last line of this says, except for deputy appointed by the executive committee or executive director, the term shall expire upon the appointment of a new state's attorney. So how long would your term be and how do you know when it would end if this is passed?
Yes. So I'll answer your question, then I'll also explain the purpose of the last line that you just quoted. So if you look at the last sentence in the proposed change to subsection A, it says that the executive committee shall have the authority to limit the term and scope of any such appointments and may remove such deputies at their pleasure. So
Explain who the executive committee is.
absolutely. So the Department of State's Attorneys consists of each of the 14 state's attorney's offices, the executive director's office, and then there is an executive committee that's comprised of a subset of state's attorneys who are elected. So they're elected by their peers to form this committee. And what the committee under this proposal would do is they would say, we would like to authorize the executive director to make an appointment as a deputy state's attorney, but we only want it to last for a year, right? Or we only want them to be able to handle these types of cases. So for example, my caseload is I only do Vermont Supreme Court appeals. It's possible that the executive committee could say, we're just going to deputize you for a year to trial run. We don't know if we like you yet. Maybe we want to fire you. And we only want you to do Supreme Court appeals. That would be within their authority. Those limitations would be contained in the paperwork deputizing me, and that's how it would proceed. Another way that this authority could be executed would be every once in a while, and this happened recently in a fairly old and fairly significant case, we need some heavy hitters in the department. So we pulled former Chief Justice of the Vermont Supreme Court, Jeff Amistoy, and former Supreme Court Justice Brian Burgess, both of whom were experienced prosecutors at the Attorney General's office, out of retirement to handle a very significant case. And they were generous enough with their time to help us. We would be able to say, we're going to deputize you as deputy state's attorneys, but only for this case. Once this case is over, thank you very much for your service, but this is all that we need from you right now. The purpose of this language at the end that you asked about is to prevent, and the language in D is to prevent this type of situation, which hopefully does not come up frequently. Let's say theoretically that there is a vacancy in a state's attorney's office. An attorney retires, or probably what this doomsday situation I'm describing would be there's a medical issue. And there have been, unfortunately, medical issues with prior state's attorneys that have required them to leave office. Let's say before the governor executes his appointment authority and appoints a new state's attorney, there's simultaneously vacancies in the deputy state's attorney's position. So let's say in Washington County, the state's attorney needs to step aside, and they're also down 2 of their 5 deputies. That means that 6 prosecutor office is all of a sudden down 3 prosecutors, and there's nobody who has the authority to appoint new deputies. This would allow the executive committee to say, Washington County needs help. And the way that we can provide that to them is to deputize new prosecutors in that county. And then that way we don't have to worry about the fact that there's no sitting state's attorney to make the appointment. And that's the purpose of that language, to make sure that we're treating the two different types of deputies a little bit differently to make sure we can fill those gaps if there ever is a worker shortage.
Representative Pango.
Thank you. So is there ever an end to this term?
There would not be an end unless the executive committee were to decide we no longer want your services, or they were to decide when at the time of deputizing the person, we only want this to last for a specific period. So for example, my deputizations right now, they have no end date. The only end date is when there's a change in the state's attorneys. So let's say at the next election cycle, we have a new Rutland County state's attorney. I would no longer, once that new attorney takes office, I would no longer be a deputy allowed to prosecute or no longer able to handle appeals to the Supreme Court coming from Rutland County. My authority would be over until that new state's attorney reappoints me. That's how it would work under the current system. And of course, that could be problematic if, for example, I have a pending case in Rutland County and the vacancy happens and my oral argument before the Vermont Supreme Court is next week.
Representative.
Do you have a pool of folks, like you mentioned the two Supreme Court justices that have retired? Do you have a pool of folks that could fill these positions?
We do it sort of as an ad hoc basis. If there's a big significant case, we might pull in one of those heavy hitters. But what's going to happen more frequently is folks like myself assigned to the executive director's office. So that would be myself, John Campbell, he's deputized in all 14 counties. Tim Lueders-Dumont is deputized in all 14 counties. And our two traffic resource prosecutors are also deputized in all 14 counties. So for example, let's say we decided, the department could benefit from having someone who specializes in domestic violence cases that could go in and say, wow, Rutland County, you just had a very serious domestic case. We're going to put our specialist in DV cases to, what we would call second chair that case with you. Be your backup, make sure you have all of the resource and expertise you need. And, that person is assigned to the executive director's office, but they're deputized in all 14 counties. So they could go and help out in that way.
So what we're really talking about here is an authority for the executive committee. It's 5 state's attorneys.
That's correct.
To say this particular deputy is deputized statewide or in these counties, we're giving them the authority to do that on their own, absent authority from the state's attorney necessarily in any individual county.
That's correct.
So it's not as if we're creating like a new position.
No. This isn't a new position. We're not asking for position numbers. There's no monetary request associated with this at all. This is truly just about what is the jurisdictional limits on a certain type of deputy's authority to prosecute cases.
Yes, I must have misunderstood how the executive committee is made up, because I thought you said initially 14 state's attorneys.
There's 14 state's attorneys, that's correct.
And what else?
So there's the Department of State's Attorneys consists of the 14 state's attorneys' offices and the executive director's office. Within the department, there are 5 state's attorneys who are elected by their peers to sit on the executive committee. Right now, there's only 4 because one of them is going through the judicial nominating process and was selected to be a judge. But there's an election and they're voted by their peers, and that's the system that currently works right now.
So again, the executive committee is really only made up of 5.
That's correct.
And then I guess, kind of the last question is, what precipitated the, move for the expediency request for this? I mean, is there a particular issue out there that we're looking to do this last minute here?
Well, I certainly apologize for the timing of this because I know it's precious and you're all looking to get out of this business. And unfortunately, I'm just sort of the legal nerd who gets to explain all of this, and I'd have to defer to our executive director about the motivations behind the request. But I'm happy again to answer any questions about how things currently work and how they would work if this language were adopted.
And I guess, again, because we're changing that process, bringing into it the executive committee and the state's attorneys and sheriff's department, we're doing that again for expediency, or, I mean, the original wording is that the state's attorneys may appoint as many state's attorneys as necessary. But now, the reason that we're going further and saying that the executive committee of the Department of State's Attorneys and Sheriffs may do that is because
they would be able to do it as well. So this isn't taking authority away from state's attorneys. They still retain the authority to make their own deputizations. It's like having two roads to becoming a deputy. You know, you can take the highway or you can take the scenic route, right? But the end result is still the same. So you're still the deputy state's attorney. You can still prosecute cases, and state's attorneys still retain their authority to deputize prosecutors, remove them at will. It's really just what happens in that unfortunate situation where there's a vacancy in an office and the need to create new deputy positions. Without this change, no one has that appointing authority. So that would be the concern.
So without being specific about any particular case, any vacancy that was created, that period of time in between there being a vacancy created and the governor appointing, there could be not enough deputy state's attorneys in any given county to proceed with prosecutions.
That would be the concern. For example, if when there's a vacancy in office, any deputies who are still in the office can continue to handle their cases. It's not like the cases are jeopardized or impeded in any way. This is really about what happens if a state's attorney leaves for whatever reason, and then we realize this office needs more deputies, and there's no state's attorney in that county who can appoint them. We need some other way to get prosecutors into this county to handle cases. And this would enable us to do that.
Representative Finger.
Well, I think maybe my question was answered. I'm really struggling with this because I feel like I don't know enough about the hierarchy and the composition of all these different committees and departments. And I really wonder why we've had the state's attorney in here before, or the person who's in charge of the state's attorneys and sheriffs. They've been in here before and have not mentioned this. So I'm trying to wrap my head around this.
So without being specific about any case, the concern is what happens if there's a vacancy created. And the request from the Department of State's Attorneys and Sheriffs is that we allow the executive committee, so 5 elected state's attorneys, to have the power alongside the individual other state's attorneys to be able to appoint deputies to handle cases that either originate from those counties or are being prosecuted in courts in those counties of mine.
You're absolutely right. And maybe I can provide a historic example based on my own experience that might help illustrate this a little bit. I don't want to divulge too much about someone's medical issues, so I'm not going to name the specific state's attorney or the county. But several years ago, when I was working at the Attorney General's office, which has a criminal division with statewide jurisdiction, there was a medical issue that necessitated a state's attorney to leave. At the time, and this may no longer be true, at the time, the Attorney General's office had sufficient resources to assist that county. And we were able to do that because we had that type of statewide jurisdiction, and we could go in. We helped cover on after hours on call shifts. and we were willing to step in and handle hearings if the need ever arose, and we were able to put a plan in place. Internally, within the Department of State's Attorneys, we realized if that type of situation ever erupts again, it would be nice to be able to have our own plan in place without having to rely on another entity having sufficient resources to help us. This is that plan. Frankly, it probably is something that we should have thought about earlier. And again, I apologize for the last minute nature of this request. I'm not the person who can explain the reasons for that, but that is the type of situation that we're talking about.
One last question.
Sure, you're not ready to represent.
Did Representative Higley just ask you if you had sufficient resources and you said yes, or did I miss that?
My understanding is that this legislative session, Annie Noonan from our office asked for something like 14 new deputy state's attorneys positions. My understanding is maybe we got 5. So do we have enough resources? No, not necessarily. I think that the state's attorneys would tell you we need more resources, but we're very grateful for the 5 that we got. And we're going to do our best to utilize those resources as efficiently as possible. And part of that could be saying one of those 5, we're going to have you be a bit of a floater. We might need to send you down south this month, up north next month. And this would allow the executive committee to make those kinds of decisions and do that type of planning with the resources that you're capable of giving us.
Thank you very much. How do we pay for this?
There are no new positions. Very clear. We're just authorizing existing deputy state's attorney to work in specific counties where they're not already authorized.
That's right.
That's all.
So we're going to have to work within our existing budget. These aren't going to be new positions that we're requesting. There's no money associated with this ask whatsoever.
Sort of like an interdepartmental.
Before you go, Representative Rowe, I just have a clarifying thing that I think might help Representative Hengo that I wanted to ask Legislative Council. So in the Senate, this was passed out of Gov.Ops and then was presented on the floor, and they suspended rules to message this over because of the urgency?
Yes.
Okay. So there wasn't this was a voice vote, I imagine, in the Senate?
Yes.
Okay. Representative Moretti, sorry to short stop you.
I recognize this need here. I think we need to be expeditious here, so I'm going to move that we accept this change the Senate sent over to us.
Thank you for that. So that would be a motion to concur with the Senate proposal amendment. Before we take a position on it, I just want to say, I know that Senator Brock, Senator Hardy, Senator Sears got together with Evan and Executive Director Campbell, talked about the need for this and the urgency around it. And obviously the process went through pretty expeditiously in the Senate today. This is an awkward vehicle for them to put it on, and I don't like surprises, especially not on what's probably the last day of the session. But those senators felt very strongly about this, and after hearing Mr. Meade's testimony, I am inclined to concur. Representative Hengo, go ahead.
Does anyone know the vote out of Senate Gov.Ops?
It was 6-0.
Thank you.
And they had a floor vote as well?
And that was a voice vote on the floor?
Yes, as I recall, it was a unanimous voice vote. There were no votes.
All right, so all those in favor of concurring with the Senate proposal of amendment? That is 1101. And thank you. So what I think might happen, Representative Higley, do you feel comfortable presenting this, or would you like to yield to me?
I'd assume you'll do you if
Okay.
there's, no
Yeah.
ins and outs of.
I think I'd prefer that. I've got some notes, and I'll confer with Evan and Jen to make sure I've got my head around what this means in case I've got questions.